Greetings and salutations, my fellow sovereigns. This is the Vocational Science of Freedom impromptu class for arbitration, and we're meeting on the Sovereign Americans United Gilded server. And I put together about an hour-long class for going over arbitration and where it comes from, where the history of it is, how we can use it, and how the VSOF uses it to enforce what we do with our status doc set. And if you'd like to join the Vocational Science Freedom Gilded server, you can do so by going to the Vocational Science Freedom YouTube page and clicking right here. It's gilded.gg/VSOF. And the link is also in all of the show notes on YouTube and on Odyssey and on Rumble. So to start out, I dropped a link for a mega file, as I always do, into chat. And this will contain all of the information that I have ever collected about arbitration. Now, I'm not going to be able to cover all this tonight, not by a long shot. It would probably take me an entire week, if not longer, to go through all of it. But at least I dropped it all so you guys can have it and go through and read it at your leisure. And the other thing that I dropped in the chat was the documents that I do want to cover tonight. And the first one is a practical treatise upon the law of writs. And I specifically say the good one because this is a very, very important treatise. And for anybody that doesn't know, a treatise is a book on a particular subject. And if you want to learn about any particular subject, not just law, but any subject, you want to go find a treatise on that subject. So say a treatise on plate tectonics, or a treatise on volcanic activity, or a treatise on neutron stars, or in this case, a practical treatise on the law of writs. So that's why you want to look up. That's why you want to look up and find the treatise on a subject that you're learning. So if you want to learn about the common law, find treatises about the common law. And if in this case, if you want to learn about arbitration, go and find treatises about arbitration. Now, I believe I have some treatises of arbitration in this library that I just dropped on all of you. But it starts up top. The folder 3 is history of arbitration, the documents that I found that were good regarding the history. And I will read from the history of arbitration practice and law. Not all of it, but it's a good little short law review. And then I have arbitration training manuals, rules, guidelines. This is all of the documentation that I found for like what the American Bar Association deals with as far as the arbitrators are concerned, and some other documents as far as that's concerned for that. Law reviews, books and law review arbitration that contain them. This is a very long folder. This is where I have a lot of most of the information in it. But as you can see, there must be probably about 30 or 40 documents in that one. Selling arbitration awards and judgments, because after you get an arbitration award, you can actually sell it to a bank after it's confirmed, but I'll get into what confirmation of an arbitration award is in a little while. And then arbitration companies. This is one that I had together from the arbitration companies that we've found so far, or that have been used by various different people in the past. The case law for arbitration, and then power of attorney. This is an aspect of something that the gentleman named Stark did. And actually, I should probably, you know what? I'll actually copy this one over into chat as well, because this is something that's going to be important as well that we'll get to in a minute. And then I will also cover the arbitration clause that is actually in the VSOF status docs in a particular document, and I will read that as well. Okay, so starting off, let's open up the practical treatise upon the law of judicial writs and process. I'll make this nice and big for everybody so they can see it. And now what I'm going to do, it might be a little bit too big. I'm going to scroll down to the start of the treatise, which is where the history of law starts. And it's not just arbitration, but it has a few interesting passages regarding arbitration. But I'm going to give everybody kind of a general overview of the history of law anyway, because this is probably the best single chapter that I've ever found in any treatise that gives a good introduction of the history of law. And it's a good side-by-side between Roman civil law and English common law. So, Section 1, the Roman law. The history of writs and process is essentially a part of the history of judicial procedure, the earliest type of which was a mock contest, each of the claimants laying hold of the object in dispute, thus symbolizing a conflict for the possession of the property in controversy. Now, what on earth are they talking about? Literally, two men would come before a judge or an arbitrator, and they would be holding on to the thing in dispute. So if it was a slave, they would both be holding on to the slave. If it was a cow, they'd both be holding on to the cow. If it was a bag of grain, same thing. They would literally be holding on to it. And this was called accio sacramentium, and seemingly for the reason that a certain sum was solemnly consecrated to sacred purposes in pursuance of a challenge by each party to the other to stake a sum of money upon the truth of his assertion. Now, we still have remnants of this. In fact, in Roman times, they would take that money and they would put it into a consecrated case. That is still to this reason why we call it opening a case. Most people have no idea where that comes from, but that's where it comes from. Also, we also see it in common law actions, certain common law actions, specifically replevin. The action of replevin is where you have to put down a bond, and then you file the suit with the bond, and then you literally go and seize the property from the other person. And then what you do is you then have the court case after you take your property back from the other. And the bond is there to protect the other person in case you lose the case. So that's another way that this kind of putting money as far as the sum certain was solemnly consecrated to sacred purposes in pursuance of a challenge by each party to take to the other to stake a sum of money upon the truth of his assertion. Well, that's still part and parcel what happens to this day, and this is where it comes from. Okay, to continue. In this most ancient of proceedings among the Romans, the appearance of the defendant was voluntary. The state exercised no power, save that the magistrate interfered in the feigned quarrel by calling out to the disputants to let go their hold, thus interposing the authority of the state for the peaceful settlement of the controversy. Then the disputed question was referred to what? To arbitration. The first judges in Rome were not judges. They were called praetors, but they weren't even judges. They were only arbitrators. So, and this is a very important point. So arbitration predates Roman civil law. Okay? That's why they can't get away from it. That's why they cannot do anything to defeat a binding arbitration clause that they willfully enter into. And I will show you how that works tonight. Okay? So to continue. Though the decision was in favor of the plaintiff, yet the state lent no assistance to the execution of the judgment, except by permitting the defendant to be taken and cast into chains, refusing to treat such an exercise of force as unlawful, and punishing any resistance to it as a crime. So when you got a judgment in Rome, and you were the plaintiff, and he didn't pay up, you could literally go put that man into chains, and the state said, no, that's perfectly fine. We're not going to interfere with that. And as it says, permitting to cast into chains, refusing to treat such exercises of force as unlawful, and punishing any resistance to it as a crime. So if the defendant resisted the plaintiff putting him in chains, that was considered a crime. Very, very strict rules here, okay? To continue, civil jurisdiction arose from the private arbitration, again, here we go, private arbitration of disputes. The first judges were merely arbitrators. The existence of the power of the state developed from the voluntary submission of the defendant, and this became the cornerstone of civil procedure in Rome. 4 periods, and we probably don't need to read this, but I'll read it anyway because it's kind of just an interesting historical context. 4 periods have been assigned to the development of Roman law, from the foundation of the city to the time of the 12 tables, from the 12 tables to the birth of Cicero, from the birth of Cicero to Alexander Severus, from Alexander Severus to Justinian. But in considering historically the subject of writs and process, 3 epochs need only be distinguished: the law of the 12 tables, the edicts of the praetors, and the imperial constitutions. From the founding of Rome, the creation and promulgation of the memorial 12 tables, there was progress in the matter of summoning a defendant to a court of justice and enforcing a judgment. This is evidenced by the extracts of the 12 tables given below, which constitute all the matter herein contained, interesting and pertinent to a historical discussion of the subject of this particular treatise. And remember, this treatise is about writs and judicial process and due process. Basically, that's what this treatise is about. But anyway, so there's going to be references to that over and over. But so you can read the 12. You can read them here if you want to. They're not that long. And I think they're continued on the next page. If I believe so. So they kind of continue at the bottom of the page all the way through. So if you wanted to, actually, I think they stop up here. So if you wanted to go ahead and read them, you can. I'm not going to bother tonight. So that's pretty much all I wanted to say about the history of that regarding arbitration. Well, actually, you know what? No, hold on. I'll read this one too. All right. The submission of disputes to arbitration now became compulsory. For while the state did not lay hands on the defendant and bring him before the court, yet it authorized the plaintiff to do so. The proceedings were still oral, meaning there was no writing. Spoken law is a higher form of law than written law. So, and I'm not digressing here. I just want to make an extremely important point about this. If you go into a court and you file motions to do whatever, to move the court to dismiss or whatnot, or even if you're filing a suit against somebody else as a plaintiff, and I don't care what court what jurisdiction you're in, doesn't matter. You file your court case, you serve it on the defendant, or you file your motion and you serve it on the defendant or plaintiff, whatever. When you get to court and you start arguing what's in your paperwork, if you start opening your mouth and start talking, and what you say deviates at all from your paperwork, you have literally just nullified everything that you took all that time to write out. So when you get to court, you shut up. The only thing you say is, Your Honor, I stand on my paperwork. I have nothing more to add. That's it. That then forces him to look, or her, to force them to look at what you've actually written. And nothing else need be said. That's it. If they have questions about your paperwork as to what is specifically stated therein, that's fine. But if there's ever a question that seems like it might be sneaky by the judge, then say, well, Your Honor, I'm not prepared to answer that question right now. And you can do that if you're a plaintiff. If you're a defendant, they might get pissy with you and really try and be like, oh, if you don't answer, I'll hold you in contempt or something like that. But that's why you always want to be a plaintiff anyway, clearly, because all the power is with the plaintiffs. So, okay, so going back to this, the proceedings were still oral, and summoning the defendant was a private act. Disobedience, which was not an offense against the law. Apparently, the defendant, if he were the stronger and had friends to help him, could resist arrest without exposing himself to any punishment. And the plaintiff could use force only after calling a bystander to witness the defendant's refusal to obey the summons. Immediate attendance at court could be avoided by defendant giving bail for his appearance. That's where bail came from, everyone. Bail is a Roman civil law thing. It had nothing to do with the common law. It's a Roman civil law deal. This is, so you're going to pay bail, right? To continue, the third of the 12 tables concerns and regulates the enforcement of an admitted liability or of an award. What's an award? What are they talking about here? Arbitration award. Because you have a judgment in courts of record, you have an award with arbitration, okay? If the judgment was not satisfied within 30 days, the plaintiff was authorized to seize the defendant and take him before the magistrate, but this time to show that the judgment was right. And this was entirely reasonable because the judgment was not the declaration of a court, but of a private individual acting as referee or arbitrator. And thus was invoked the coercive authority of the state. This proceeding to enforce a judgment was denominated an action, actio pers manus injectiundum, and was the purpose of legalizing arrest, which resulted when the defendant failed to discharge the debt. If the judgment was pronounced valid, the person of the defendant was adjudged to the plaintiff unless defendant paid the debt or brought someone forward to guarantee its performance, which was giving security. So someone else could step in and give security for the defendant if he couldn't pay. After the lapse of 60 days, the judgment Being still unsatisfied, the debtor was brought before the praetor on 3 successive market days, and the amount of the debt publicly declared, after which he may be put to death or sold into slavery. Right there. You want to talk about some severity? There it is. But this is still what we do today, honestly. Truth be told, if you're the plaintiff and you have a judgment, you're the one that's supposed to actually be carrying out the judgment of the court. And I'll make a point about this. There's a reason why all law enforcement agents have a shield as their symbol. Now, no one pays attention to where this comes from. Okay, so you as the plaintiff are supposed to bring the sword, and they are supposed to bring the shield and protect you as you take back what is lawfully yours. That's why all sheriffs' symbols are a shield. That's why they carry a shield. Their badge, it's a shield. It's only symbolic now because men don't walk around with shields, but that's the reason why it's there. Okay. So under the edicts of the praetors, there was much progress in judicial procedure. It was impressed upon the citizen that he should be ready to answer in court any complaint brought against him. And while the summons was still given orally and remained a private act, yet disobedience thereof was made an offense. Want of jurisdiction of the court named did not avail him as an excuse, it being required that such plea be made in court. It was declared to be an offense to rescue a person summoned or to aid in his escape. Before summoning a certain class of people, the praetor's leave was necessary, meaning you couldn't go after people that were too high up in the chain, if you will. Like you couldn't go and arrest, say, like a Roman senator. So anybody that was upper class in Rome, you had to go get leave of the praetor before you could go do that. And then probably the praetor could tip off the upper class citizen and then whatever, right? So he could kind of disappear for a little while, maybe. So anyway, this is a sense literally of how the corruption is still to this day goes on in court systems, but I digress. Anyway, to continue, nor was it permitted to drag a stubborn defendant from his house. Also interesting. You could not go into a man's house. So the house was still the castle back then. Interesting. Just an interesting side historical point. If one purposely avoided being summoned, official notice was given to him to appear, disobedience of which gave the plaintiff the right to take the possession of his property. And from this practice arose the enforcement of judgments by seizing the property instead of the person of the debtor. So I think I'm just going to stop there because I think the rest of this just gets into, the rest of due process, and I don't need to go through all that. There's another interesting part here about the English law. This is the starting of the history of the English common law, but I will just skip that because that is not what I brought this up to talk about tonight. So that's all I really wanted to read from that particular treatise. Okay, now next let's open up the history of arbitration, practice, and law. And I'm just going to skip through some of this real quick. This is just a law review from Cleveland State University, and I found it to be fairly interesting. So long before laws were established, or courts were recognized, or judges formulated principles of law, men had resorted to arbitration for the resolving of discord, the adjustment of differences, and the settlement of disputes, as we just learned. One of the earliest arbitrators was Solomon in a book by El-Uri and El-Uri, must have been, two siblings. How Arbitration Works, 1960. The authors not only stated that Solomon was an arbitrator, but also noted that the procedure used by him was in many respects similar to that used by arbitrators today. An account of one of Solomon's arbitrators in the Old Testament is found in 1 Kings chapter 3, verses 16 through 28, and reads, Then came 2 women that were heralds unto the king and stood before him. And the one woman said, O my lord, and I and this woman dwell in one house, and I was delivered of a child with her in the house. And it came to pass 3rd day that after I was delivered, that this woman was delivered also, and we were together. There was no stranger with us in the house, save we 2 in the house. And this woman's child died in the night because she overlaid it, meaning she literally slept on it. And she rose at midnight and took my son from beside me while thine handmaiden slept, and laid it in her bosom, and laid her dead child in my bosom. And when I was arose in the morning to give my child suck, behold, it was dead. But when I considered in the morning, behold, it was not my son, which I did bear. And the other woman said, Nay, but the living son is mine. Or sorry, the living is my son, and the dead is thy son. And this said, No, but the dead is thy son, and the living is my son. They thus spoke, basically, before the king. And the king said, The one saith, This is my son that liveth, and the son is the dead. And the other saith, Nay, but my son is the dead, and my son is the living. And the king said, Bring me a sword. And they brought a sword before the king. And the king said, Divide the living child in two, and give half to one and half to the other. They spoke the woman whose the living child was unto the king, for her bowels yearned upon her son. And she said, O my lord, give her the living child, and in no way slay it. But the other said, Let it be neither mine nor thine, but divide it. Then the king answered and said, Give her the living child, and in no way slay it. She is the mother thereof. And all Israel heard the judgment which the king had judged, and they feared the king, for they saw that the wisdom of the God was in him to do judgment. And out of this dim recess of fable and mythology, it appears that upon Mount Ida in Greece, the royal shepherd Paris was also called upon to deliver a famous arbitration award. The dispute concerned the contemplating of Juno, Pallas, Athene, and Venus for the prize of beauty. So this is just another story. I'm not going to get into it. I'm going to get down here a little bit farther. I think there's a place in here. Hold on. Arbitration literature of this early period is exceedingly sparse, and inquirers are therefore handicapped in examining the somewhat vague course taken by arbitration and the course of its inaction. Such record as exists appears generally in court decisions rendered in the course of controversy over the process of arbitration, rather than in its normal usage by individuals and trade groups. Prior to World War I, America had its great judges, scientists, authors, artists, and other leaders, but arbitration could claim no such distinction. Arbitration appeared to have been homeless, friendless, wanderer among men and nations, remembered only in periods of acute distress when it was often too late for it to be of service. Although arbitration had found a foothold in chambers of commerce as early as 1768 in New York, 1794 in New Hampshire, and 1801 in Philadelphia, the example set had not resulted in its general acceptance by other chambers of commerce, and even when established, it was not generally used because little effort was made to educate the public in its use. And that's how basically it came into America. It was in these chambers of commerce. And Leah found something today too about some passage. What did you find about passage chambers of commerce or something you were saying today? I forget what it was, but something you'd found about that the first arbitration, I think, was in Pennsylvania regarding a chamber of commerce. Or no, it was in New York. Yeah. So it must literally be this thing is where they found it here. So the only clear record of development in arbitration was still to be found in the court decisions interrupting such common law and statutory provisions as were applicable to arbitration. Though these decisions pertain, certain principles and policies of immense significance to the future development of arbitration had been established, but they offered no clear view of the normal history, development, or progress of arbitration in the United States or of its relation to public welfare, nor did they portray arbitration as an institution having a definite impact on the economic life of the country, because back then it truly didn't. But now, just pause here a second based upon that little snippet of information. What do you see now? Every single time you turn around, every single time that you enter into a user-end license agreement for, say, the use of a software, what do you find? There's an arbitration clause in every single user-end license agreement. Every one. Why? Because they don't want to actually go to court. They don't actually ever want to have 12 members of the peerage decide whether this company is doing something lawful or something that they should be doing or not. No, we don't want that. Instead, we want a binding contract that then only goes before an arbitrator that can only then give a judgment based upon the validity and the aspects of the parties binding themselves to said contract. That's it. That's what they want. Now, I've known this for years, and I thought, okay, well, if they can do it, so can we. And I'll show you guys tonight how we did it, and to the tune of several $1 million, in fact. And I'll show you another example of a man that did it to the tune of a couple $1 billion. Well, not a couple, it's actually multi-billion dollars. But that the Starks Award is absolutely insane. And it had to be passed as a private bill in Congress. But anyway, I'll get to that in a minute. Okay, so I just want to see if there's anything else in here that I want to read for you guys real quick. Yeah, you guys can read this on the rest of it on your leisure. It is a good little layout of history, but I just wanted to kind of maybe this little. Okay, so during the first year and a half of 1922 and part of 1923, the Society recorded the distribution of 158,000 pieces of literature and 1,200 meetings, conferences, or gatherings where arbitration was discussed. Okay, so by 1922, it was getting going. It received 600 applications of information of the settlement of disputes. Furthermore, during the Society's lifetime, from 22 to 26, there were enacted modern arbitration laws in both Massachusetts and New Jersey. The Society was also instrumental in effecting and enacting the United States Congress of the arbitration laws in 1925, applicable to interstate commerce and foreign trade transactions. Okay, so this is getting into the history of some of the legislation. And now, what controls, and I guess I'll just leave it at that and just now go to the controlling aspect. So there's two things that control arbitration, all of it. So there is, I don't know if I had this in here in the history. I don't think it's in the history. Let me look real quick, because there's two different sides of arbitration. One is what's called the FAA, which is the Federal Arbitration Act, which is literally Title IX. So, if you look up Title IX of USC, that is literally the FAA. That is the FAA and that's all that's in Title IX. It's all about arbitration. That's it. So Title IX is the Federal Arbitration Act. So everything that you'd want to do, if you'd have to take something into federal court regarding arbitration, all the rules, all the regulations, all the controlling law is in Title IX. That's it. Now, the states do something different. So under the states, they have the Uniform Arbitration Act. And the UAA gives guidelines as to what the states basically have to do or should do. And pretty much every state has now adopted it. Now, I don't know if I have a copy of the UAA. And like I said, again, it's just guidelines. But every single state statute, you can look up what the laws are regarding arbitration in the annotated statutes. So you guys can, or somebody could probably go look it up right now and just say, like, drop an example of it into chat. Would be perfectly fine. And you can read what the rules are for arbitration in any particular state. And some of them differ, and they don't differ too much because they've all pretty much adopted the UAA, the Uniform Arbitration Act. And and where that comes from is, okay, that's Title IX. Thank you. That's the federal side. And where it comes from is the whenever you hear the word uniform, it always means that it came from the Commission on Uniform Laws, which is a group of attorneys that got set up in Chicago, like in the early 1900s. I think it was like 1902. And they have been working to basically, if you will, kind of wipe the slate clean of all the state laws and make them all uniform, because attorneys are stupid and they don't want to have to learn different law when they go to a different state if they want to go practice in a different state, because they want to jump around and bounce all over the place and practice wherever they want to. So instead of having to learn a whole new set of laws and a whole different way of doing things when they go from, say, Massachusetts to Texas, the Commission on Uniform Laws, this monstrous group of attorneys, has been slowly eroding away and creating uniformity through all the state legislatures for the past 125 years. And yet no one's paying attention to what they're doing. So anyway, that little piece of history aside, now what do you do? Okay. So from that, let's now read an arbitration clause. This is the arbitration out of one of the vocational science freedom status docs. And this is the status doc that we call the KW, the one that actually gives them an offer of contract for administration of our state. So in short, I'll give you a short rundown of what the VSOF status docs do. They put down the fact that you've been found to be living, that you've come of full age, that you've claimed your estate, that you remove all power of attorney from any aspect of any part of your estate or any trust that takes any res from your estate or yourself. It nullifies all contracts with the corporate state without question. And basically what it does is it wipes the slate completely clean. Completely. And then it establishes your own house. It establishes your own house seal. It also places proper claim onto your entire gross estate by putting a particular type of endorsement on the backside of a duly authenticated birth certificate that's both authenticated on the state and federal side, which then is as good as the original, which we pretty much know is sitting at the DTCC. And someday we might get the originals back once we completely finish everything else that we're doing. And the other few things that the status docs do, and I'm like, again, I'm going over this very quickly just so you guys have an idea of what all the other things they do. It's an offer of contract from your house to all the world that says, if you administer any part of my estate, you then bind yourself to this open offer of contract to all the world, and you then agree to be a trustee of my estate. And once you do that, you also agree that you must put up a $300 million bond for potential fiduciary malfeasance for any problem that you might cause in the administration of that estate. Meaning if you don't follow my executive orders, if you cause waste, if you have an account in the estate name someplace and you're trying to make interest off of it, every single one of those requires that you automatically are bound to create and put up that $300 million bond. And if you fail to do so, I get to take you to binding arbitration for that same amount. So that's what we did. It's what I did at the VSOF. I wiped the slate clean and I said, you guys want to play this game with arbitration? Great, let's go. And the arbitrators have agreed with us. And they also agreed with Stark too. All right, so I'm going to read the arbitration clause here from the KW. So arbitration and court of record clause regarding procedure of disputes arising from claim. And claim is this entire document. That's what I've called the entire document throughout the document. Okay, so arbitration. Claim constitutes an agreement, covenant, and binding contract between claimant, that's you, and all bound trustees, that's anybody who administered your estate, and all third parties who bind themselves to claim by performing any binding actions stated herein. And the binding actions are listed above. I won't go through them, but it's things like I said, administering your estate, holding accounts in the estate name, and so on and so forth. There's a long laundry list of them. All parties agree to submission to binding arbitration regarding any dispute regarding claim as specified herein. And in the event a bound trustee fails to perform as required herein regarding any clauses to which they have bound themselves, as stated herein, claimant has the choice at that time to resolve all disputes by actions in a court of record and or submission to binding arbitration as defined herein. If claimant chooses binding arbitration, meaning you choose binding arbitration, all trustees agree to submit themselves to the arbitrator or arbitration company of claimant's choosing, and that said arbitrator or arbitration company shall be the designated arbitrator for said dispute. In the event of non-acceptance of appointment as arbitrator and or any physical or mental incapacity to act as arbitrator, the claimant shall have the authority to select any neutral arbitrators that qualify, and any controversy or claim arising out of or relating to any way to claim or with regard to its formation, interpretation, or breach, and any issues of substantive or procedural arbitrability shall be settled by arbitration and by said arbitrator. If claimant chooses arbitration and not an action at law, the arbitrator may hear and decide the controversy upon evidence produced, even if a party who was duly notified of the arbitration proceeding does not appear. Where do you think I got that from? The arbitrator will not and does not have the authority to disregard or refuse to enforce the law decreed herein, nor the law decreed by claimant in any other paperwork regarding the estate and trusts which is submitted to the arbitrator. Meaning you then just bound the arbitrator to only the law that you decreed. All disputes arise, because this is the contract. So the arbitrator's bound to it too. They have to follow the contract, and this is something that you can do to arbitrators. You can tell them what they must be bound to, as long as it doesn't fall outside of the privy of Title IX or the UAA. Where'd I leave off here? The arbitrator will not and does, okay, I already read that. All right. All disputes arising from claim shall first be attempted to be solved by and through negotiations between claimant and the appointed trustees. Meaning, I'll talk to you, right? You want to have open discussions about this? No problem. If the claimant by any appointed trustee cannot resolve a dispute through negotiations, and the claimant chooses to resolve the dispute by arbitration, the claimant and all bound trustees agree and consent to submit any and all disputes which could otherwise be submitted to a court of competent jurisdiction to arbitration. Arbitration hereunder, these conditions said, shall be the claimant and all appointed trustees or third parties' exclusive remedy, and the arbitrator is empowered under this claim to make any and all necessary and appropriate orders, pre-award rulings, and awards, granting both legal, lawful, and equitable relief to enforce the terms and obligations of this claim, including all matters relating hereto and arising therefrom. In the event of any conflict of laws, maxims, facts, provisions, terms, clauses, conditions, definitions, orders, or rules arise regarding any arbitration dispute of claim, then what is stated in claim, meaning this document, shall govern. If claimant chooses binding arbitration, all bound trustees, regardless of the degree to which they bind themselves to claim, because there are increasingly severe binding clauses in the KW. It gets worse and worse and worse for them if they keep wanting to try and do what they're not supposed to be doing. So that's just what that's in reference to. I'm not going to go read them, but that just you understand what I'm talking about here. Okay, bind themselves to claim, agree to enter into and consent to be binding arbitration under the terms and conditions of claim, and all bound trustees of any degree waive all rights to vacate, modify, appeal, or collaterally attack the decisions, rulings, orders, remedies, and awards, both interim and final, of the arbitrator. What did I just do? I just castrated them. Once that arbitration award comes in from the arbitrator, that's it. They can't go running to a judge. They can't appeal it. Nothing. You're stuck. End of discussion. Excuse me. To continue. All United States trustees furthermore agree that transporting people or persons without their consent across state lines is human trafficking, and evidences a transaction involving or affecting commerce within the meaning of Title IX USC subsection 1. What did I just do there? I just stopped the entire corporate state from ever arresting you and taking you across state lines. That's what that did. And with the enforcement of human trafficking, and we know what that means. That means that then you can bring in President Trump's executive order regarding human trafficking, and you get to seize all of their assets, because that's what that executive order says. Now, I don't give a damn that I didn't spell that out right there. I don't have to. That's just the law. So, but anyway, to continue. Furthermore, all bound trustees agree that claimant can secure damages via any and all actions under reservation of right of prosecution at any time for all injuries sustained and inflicted upon claimant, the estate, or trusts for any wrongs committed against the same, as set, established, agreed, and consented to herein by the bound trustees by their binding actions, to include but not be limited to. And this is where I opened it up to, yeah, I'm going to come and do binding arbitration against you, but I can also hit you with everything else I want to too. I'm not saying that my only remedy is binding arbitration. So that's what this is kind of what I'm doing with this clause. I'm opening the rest of it up. So I'm saying, okay, look, by the contract, I'm not binding myself to only be able to go after you for binding arbitration. I'm saying, look, I've got all the rest of this open to me as well. And that's what that means. All actions under right of reservation of prosecution. That means I reserve any and all remedy that I want to bring against you. It's basically what that says. Okay, so all injuries sustained and inflicted upon claimant, estate, blah, 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 blah. Agreed to and consented to herein by bound trustees, their binding actions to include, but not be limited to, constitutional impermissibility, misapplication of statutes, laws regarding claimant, the estate, and trusts, which include, but are not limited to, alleged criminal case cause, trespass, false arrest, false imprisonment, fraud, conspiracy, theft, deprivation of rights, human trafficking, all tort claims, trespass of title, probate fraud, property damage, and the like, and all other known and unknown trespasses and moral wrongs committed through ultra-virus acts of all involved herein, whether by commission or omission. Final amount of damages regarding said to be calculated prior to submission of said actions, but already estimated in excess of $300 million, with or without notice to bound trustees by invoice. Meaning, I don't give a damn if all you do was put cuffs on me. That's it. You're stuck. $300 million straight to binding arbitration. Have a nice day. Okay. Trustees consent to and agree that claim. All other agree that claim and all other executive orders hereinafter served upon the said bound trustees, meaning you acting as executor can serve them executive orders, tell them what to do, and the required bond that all trustees in dishonor must post as stated herein becomes the security agreement between claimant and said trustees under commercial law. Period. Trustees consent to and agree that judgment shall be entered and confirmed on any arbitration award in favor of claimant in any court of claimant's choice. I had to add this little clause here because what they were trying to do after we got the arbitration award is they were trying to say, well, we didn't agree to where the award was going to be confirmed at. And you can't do it in that one, or you can't do it in this one. And they kept trying to say that. So I had to put that clause in here. So it says, no. Okay. Trustees consent to and agree that judgment shall be entered and confirmed on any arbitration award in favor of claimant in any court of claimant's choice. So I got rid of that problem because it was becoming a problem. And that said court shall have jurisdiction over the matter of confirmation. And this means you could do it in your backyard, literally. That clause just made it so you could open a court of record in your backyard and confirm it yourself. So, anyway. Trustees further agree that trustees have no right, authority, or cause to attack, set aside, or vacate any arbitration award or court of record judgment regarding claim. That's my arbitration clause in one of the most important documents in the VSOF status docs, okay, which we affectionately call the kill warrant. That's not the actual name of it. The actual full name of it is lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for same. So that is the KW part of it. So that's the arbitration award. The arbitration clause. Now, what does that arbitration clause get you? Okay, well, there was this guy that I knew in Colorado. And what did he do? He had a problem with the court system. What did he do? He decided to go court of record. So he did, and I helped him, and we went through all of his cases, and we defaulted them and said, you guys don't have jurisdiction. They said, we don't care. We're going to keep moving forward. We said, okay, then we can take this to binding arbitration. They say, we don't care. Okay. So we took it to binding arbitration, and this is this gentleman's award. This gentleman, Brent Nelson, is the claimant. His name's Drew, or he calls himself Drew. And this was the binding arbitration award that came back from the arbitrator based on the arbitration clause that I just read to you. This award is based on the contract that I just read to you. Final arbitration award, breach or violation of required contract terms. This is 6 pages. I don't think I'll read all of it. But anyway, the parties have agreed to the judgment of the court shall be entered upon award made pursuant to the arbitration and shall specify the court, I'm going to get down here. So who is it? Arbitrator's name, this guy, location, California, arbitrator, subject matter is acknowledged by Title IX U.S. codes, Claimant, Brett Nelson is citizen of the state of Colorado. That should be a capital C, but whatever. Respondents, this is either 2 judges and 2 district attorneys or 3 judges and 1 district attorney. I can't remember. The parties into a contractual agreement on October 7th, 2019. This was the date that Drew served them the KW and the VSOF status docs. And he had the process server write out a process service affidavit, so he had proof that they got served. Wham. That's when the contract starts. It is uniformly settled that a court's right to vacate or modify an arbitration award is extremely limited. That said, many state arbitration statutes, as well as Federal Arbitration Act and the Uniform Arbitration Act, these are the things that I was telling you guys about, allow correction or modification of an evident miscalculation in the arbitrator's award. See USC 9, subsection 11. I guess we could literally go look at that right now, considering Leah dropped it in here. I actually am rather curious as to what that might say. Come think of it. So subsection 11 is modification or correction grounds order. These probably are pretty short. Okay, right here. Same modification, correction, grounds order. In either of the following cases, the United States Court in and for the district wherein the award was made may make an order modifying or correcting the award upon the application of any party to the arbitration. Where there was an evident material miscalculation of figures or an evident material mistake in the description of any person, thing, property referred to in the award, where the arbitrators have awarded upon a matter not submitted to them, unless it is a matter not affecting the merits of the decision upon the matter submitted. Okay, fine. C, where the award is imperfect in matter of form, not affecting the merits of the controversy. The order may modify and correct the award so as to affect the intent thereof and promise justice between the parties. Notice that none of that says that they can vacate the order. It only says they can modify it. And very limited too, by the way, and only by what the original award said or by what the contract said. So just keep that in mind, because that's important, because they really can't do much of anything once this gets basically cured. Many states have held that an award can be corrected only for miscalculations, as again I just said, read. Okay, so anyway, I'm just going to get down to the point here as to what they said. This arbitrator finds that Daniel A. Wazzle, that is a sitting judge in Colorado, you can go look his name up right now, has a dual capacity, one as an officer of agency of the government, the other as a private citizen. It is well established that private citizens have an absolute right to petition the government and redress of grievances. Therefore, an inherent duty exists. Did the respondent have a duty as a private citizen to respond to the claimant on behalf of the agency or himself? Normally, had the respondent responded, the response by this arbitration to the above referenced questions would have been no. However, as an arbitrator, okay, I think I got knocked out for a second. So I was in the middle of reading the arbitration award. Okay, so I think I was here. If I wasn't, here we go. So Daniel A. Wazzle, again, this is the sitting judge in Colorado, is the only respondent named in the performance contract. Was there prior relationship to the parties? Did the named respondent perform under these terms of agreement? This arbitrator finds, based on the record and evidence presented, that a relationship did exist between the parties via various docketing matters. Was the respondent required to respond to the claimant's questions that directly pertain to the prior relationship? This arbitrator finds that Daniel A. Wazzle has a dual capacity, one as an officer of the agent of government, the other as a private citizen, as well as it is well established that private citizens have an absolute right to petition the government to redress grievance. Therefore, an inherent duty exists. Did the respondent have a duty as a private citizen to respond to the claimant on behalf of the agency or himself? Normally, had the respondent responded, the response to this arbitrator to the above referenced questions would have been no. However, as an arbitrator, I may not go into the evidence presented, and the evidence is that the contract at bar is a commercial agreement. So this is where he said, yep, you're bound by that contract. So notice of default. The respondents have been notified on several different occasions, and the record presented demonstrated that they have neither timely disaffirmed nor rejected the agreement in the manner prescribed. In fact, what they did was they bound themselves to it. This arbitrator has no evidence to the contrary, presumes that the respondent had chosen not to respond, and in doing so has elected to have judgment entered against him should he prove to be in default, which he clearly was. This arbitrator further finds that the respondent did knowingly and intentionally enter into a contractual agreement, and after entering into said performance agreement, has breached the agreement after being granted ample opportunity to cure the miscarriage. This arbitrator further finds that the respondent, by virtue of default, has waived and surrendered any right to protest, contest, complain, and or retaliate. Please note that the claimant has alleged retaliation, because after he did this and he went after the judge in binding arbitration, the judge put out an arrest warrant for him. No reason, just go get him, right? Well, that's retaliation. And there's a part of the KW that says if they retaliate, that they have to pay double. But anyway, yet such is not to be considered at this time, as the language of the contract construes such as happening after award is issued, even if such is not the intent. This arbitrator finds that such evidence was untimely, because I changed this too. And Drew actually went back at him and he's like, that's not what the contract said, man. You better go read that. But anyway, not well organized and must be promptly applied for. It is further noted that many other related documents were attached. However, only those named in the original instant contract may be considered, as anything outside of the agreement is beyond the scope of this arbitrator's authority. Fine, whatever. Respecting the default judgment by the Superior Court, this arbitrator notes that judicial immunity cannot be waived under such circumstances, as the contract only permits the arbitrator to declare a party in default and render judgment. The contract does permit the claimant, non-defaulting party, the right to seek compliance with contractual obligations. Therefore, the claimant may enforce, yet not per the contract, through this arbitrator, value of award. Meaning, what he said here was that you've got the right to go back and go after him in a court of record for various different other things if you want to, basically is what that said. This arbitrator has read the agreement and is noted that the award is not to exceed, yes, that says $10 million. Noting the intentional default by the respondent, the consent to the obligations of the agreement, and the failure and or refusal to comply, this arbitrator does find that the default has not yet been cured, was deliberate, and hereby orders the respondent, Daniel A. Wazzle, that's the judge, in his official capacity, meaning as a judge, to pay the claimant $6,898,000 and to comply with the terms and conditions of this agreement. Failure to comply may result in an award that is accompanied by sanctions. Therefore, is decreed this arbitrator as intended herein, and so ordered, such and such, respondents, so awarded, da-da-da. Signature. Have a nice day. So, what did Drew do with this? Drew, after we did a little bit of reading into Colorado law, found out that if you go and you take an arbitration award and you file it into the county land record, it automatically becomes a lien against the property so adjudicated. Well, this is what Drew did. He went on to another website. I forget which one it was, but it's one of these websites where you can track down people. So he put in the judge's name, found out, and then he went down to the county recorder's office in Colorado, found out where this judge had, any place where this judge had property. So this judge had 6 houses, 6, all around Colorado. Drew notices him and actually process serves him the arbitration award. Now, granted, you got to remember, he already went down to the county recorder's office. He knows where all of his houses are. And he's got a copy, screenshot, of all of the information that's in there regarding where the houses are, how much it is, or how much they are, and where they're located, right? So he has a screenshot of all this. He then tells the judge that he's got an arbitration award against him. 5 days later, he goes down and he checks the county records again, and this judge moved 5 of those 6 houses out of his name and put them in his mother's name. Now, that is felony secreting of funds. That judge just committed a felony. And this is what they put in, and you want to look at it. This is the SOS filing, Secretary of State filing. And I don't know if I dropped this in chat. I think I did. Let me double check, make sure I did. So go and open up the SOS lien filing, Waltz. That's what I'm looking at right now. Okay, so once Drew went to the county recorder's office and he recorded that arbitration award, this is what is on the Secretary of State of Colorado's website, and it is still a valid lien. It is still there. Now, you might want to read this very carefully. Name, Daniel Austin Wazzle, in his capacity with the state of Colorado, such and such address, yada, yada, yada. Claimant, individual, last name, Nelson, Brent, Andrew, yada, yada, yada. Property, description, all goods, chattels, lands, tenements, and real estate. Drew has the state of Colorado on the hook for $7 million. And this is already on the Secretary of State's website. It's valid and it is binding. There is nothing they can do about it, except what they did do, which is they threw him in jail. And they locked him out of the entire Colorado court system. He's been sitting in jail for about, I think it's going on 6 months right now. And a friend of mine and a few other people who are in Colorado, who were well aware of the whole situation, they said, what the hell just happened? And I was like, yep, that's what they did. So what they did was they went and raised hell and high water to a bunch of courts, and they got the court to basically appoint a special master. So to basically see, okay, what the hell is going on here? So the special master did an investigation, went through all of Drew's paperwork, and came back and said, we don't know what this judge is doing, and we don't know what this court system is doing, because what he did was correct. Everything that Drew, their own guy came back and agreed with Drew. So now it's basically sue the court, sue the judge, get him out of jail, and then go after him for even more, including the felony secreting of funds and the basically what tantamount to aggravated kidnapping with intent, because he had this judge and has this judge by the balls. He's the entire state of Colorado under the bus at the moment. as you can see by this lien. If you guys go look up this lien on the Colorado State website, it's still there. So that's that. So that's what we did with Drew. And this is all stuff that I've done with him to take care of what we did there. Now, another thing about I want to show you guys is another award, arbitration award, just so you guys can really see how powerful this can get, if that wasn't enough. Let me see if I think I have Stark's award in here. Hold on, I gotta find it. What did I might not have put it in here. Okay, so this is Stark's power of attorney. Oh, that's the other thing that Drew could do too if he wanted to. Drew could literally take power of attorney over that judge and sign over all those houses directly to his name if he wanted to, because there is a clause in the KW that allows you that also allows you to take irrevocable special power of attorney coupled with interest. And I don't think I dropped that, but this is Stark's, the one that Stark did. It's very well written. I basically just copied and pasted it for the most part into the KW. But what I'm looking for is Stark's. Oh, it's right here. Sorry, it was right in front of me the entire time. So this one, I don't know. Let me check and make sure that I dropped this in chat. This is Stark's award. And wait, yeah. So no, wait, hold on. That's the power of attorney. I already did that. It's this one. This private bill. There we go. Sorry. Okay. This private bill, this private law, 114-31. This is now considered to be national security. You cannot find this anymore. So be careful you give this to. If you want to open this up, this is a whole different ball of wax. So private law, December 3rd, 2016. So Bradley Christopher Stark did tantamount to the same thing that I just did with Drew, but he did it in a slightly different way. He basically got him under contract before they were going to sentence him, and he made him an offer of contract and proved to the fact that they were all private for-profit courts that were coming after him, and so therefore so everything is about contract. Everything's about offer and acceptance, which you may not heard some people say. I don't really tend to say things that are all-encompassing or things like that. But anyway, and so an act. This is a private law. Stark did. He basically put the entire United States Federal Corporation under the bus by arbitration. He took power of attorney over Eric Holder, who was the Attorney General under Obama, of which you can see the special power of attorney, by the way, coupled with interest. Eric Holder's name is literally in there. And after he got the arbitration award, this is what Congress had to pass as a private bill to pay him off. And you are not going to believe the amount of money that's in this private bill. I'm just going to scroll down because you guys already know how this works. And he did it through Title IX. I'm just going to scroll down to some of these amounts because you wouldn't believe it if I told you. Okay. So here's all of the creation of sub-trust funds. These are all these trust funds that had to get set up because of the amount of money that this thing created. Unbelievable. Anyway, transfer to sub-trust fund. They are hereby appointed from superfund amounts equivalent to, on the date enacted, takes effect, $1 million per sub-trust fund. But get this, look at this number. That's $4 billion with a B. $4,800,478,257 for the Bradley Christopher Stark Justice Relief Fund. That's just one of them. Look at the rest of these numbers. $800 million, $9 billion, $6 billion, $800 million, $800 million, $800 million, $800 million, $14 billion with a B right here. $20 million, $17 million. These are all real numbers. This is a real bill. It really was passed. Obama did sign it, but only after he sent it back once because he said, I want money for my presidential library. And Stark said, sure, I don't give a damn. And he literally put it in there for Obama, and then Obama signed it. Not kidding. This is how this went down. But these amounts are not a joke, okay? So this is how powerful binding arbitration is. This is the stuff you can do with binding arbitration because they can't get out of it. As Stark clearly proved by going at him that way, and what I just clearly proved by what I did with Drew. This private, corporate, for-profit government is not all-powerful. It is not God. It is, in fact, very fallible, and it is, in fact, completely so corrupt that it is so easy to get them under contract. It's ridiculous, if you know what you're doing. So, with that having been said, can you guys hear my heater in the background at all? That thing might be a little bit loud. Is it coming through on the audio?
No.
Okay, good. All right, good. That means my mic filter is good enough not to hear it. Okay. So is there anything now? Let's just open it up for the rest of it. You guys can ask me any questions you want about any of this. I just wanted to make sure that I got this all on the record for you guys, so it's recorded and we can save it and I can put it up later on YouTube or whatever. Well, actually, I can't put it up on YouTube. I'm only going to put it up on Odyssey because I shared this private act, and like I said, this private bill is now considered national security. You cannot find it anymore. They ghosted it. But here we go. Effective date. This act shall take effect 60 days after enactment. Speaker of the House, Representatives pro tempore, Mac Thornby, acting President of the Senate pro tempore, John Cornyn. There you go. Bam, bam. So it's done. That was a private act, and it was passed on such and such a date. And it even says, for the relief of Bradley Christopher Stark, Sean Michael Rideout, and certain named beneficiaries, it be enacted by the Senate and House of Representatives of the United States of America and Congress assembled. La, 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 la. So, there you go. So, any questions or comments? Curiosities? No?
Well,
yes?
Basically, this is the reverse engineer user and license agreement that like Google or whoever writes. And basically anybody who uses their products is bound. Like, it's a strange form of tacit agreement agreement through action instead of like a signature.
Yes, it's called a performance contract. So all these binding arbitration clauses in user and license agreements they're referred to as what's called a performance contract. You do not have to sign your name to be bound to it. If you perform, you're bound.
What are the requirements to? Because at what point does it become void? Like if there wasn't proper like notice or something that you were even entering into a contract.
That's true. You do have to give them proper notice, but of course the vocational science freedom status doc set does get process served on every single department, agency, aspect of the entire corporate government, both state and federal.
And so the fact that it's process served is enough notice?
That's always notice. You get process served with something by a process service agent, you absolutely cannot get yourself out of the fact that you had notice, because the process server then signs what's called a process server affidavit. They swear under penalty of perjury that they gave X to John Doe on such and such a date. That's it. They're done. They're noticed. They have it. The way that companies, like say software companies do it, is they do it by say, if you click yes, if you click that little yes button and you start using our software, bam, you're bound. It's called a performance contract. So if they start administering our estate, bam, they're bound.
And
that's
they have
it.
To give you an opportunity to read the contract and then check the box, say I agree, right?
That's right. And exactly. And it doesn't matter if they read it or not. In fact, there's a lot of judges and different district attorneys that say, oh, I don't care what you wrote. Okay, great. Thanks. Please don't read it. Moron. I don't care. You're still bound. I thought I had some other examples of arbitration clauses from, or wait a second. I think I know where I got them. I think I might have them in a separate folder.
How do we know that it doesn't matter if they read it or not? I mean, it makes sense. If you're just going to be ignorant enough to, to click I agree, which, I don't know, I've done before stuff, but I could try to read.
I was going to say if I have any user and license. I guess I know I have a folder of them somewhere. I just don't know where they are at the moment. I should have grabbed them before class. Sorry, guys. But no, it says it also says in the one that I read to you guys tonight, the KW, that it specifically states in the contract that it does not matter whether the bound trustees have read or have not read, but that said will come into full force and effect upon such and such, basically upon notice and service of same. So that's it. That's all you have to say. You don't have to
like work, because I've been taught that like a full meeting of the minds needs to happen for a contract to be valid. Otherwise, it's one of the basis for avoiding the contract.
But it is full meeting of the minds, because it was process served, you had notice of it, and you chose to act on it. No one forces you to administer somebody else's estate. No one forces you to click yes and start using a piece of software. Nobody forces you to jump over somebody's fence and trespass. But if there's a contract connected to somebody's fence, and it says if you jump over this fence, you're bound to this contract, guess what? You jump the fence, you're bound. That's it. So, yeah. I mean, as it's clearly stated in the arbitration award.
I guess it's not a silver bullet, but because you have to know what you're doing, you have to serve it properly, and you have to follow the proper the noticing is easy enough, but then you have to know how to go into arbitration and get that done for yourself.
Yeah, you just file it with an arbitration company. Yeah, but the funny thing about arbitration...
Yeah, I know you say that so simply, but to somebody who's such a layman...
The fun thing about arbitration companies is that they actually hate attorneys most of the time. They don't hate attorneys. They hate the court system. Usually the people you find usually attorneys that you find running arbitration companies really don't like the court system. They're kind of at odds with it. And this was, by the way, the last thing I just kind of popped open because why not? This is the special power of attorney that Stark took over Eric Holder. It's only 4 pages, so it's not too long. But irrevocable special power of attorney coupled with interest. Self-executing special power of attorney coupled with interest to facilitate your strict compliance with the terms of the contract number, blah, blah, blah. The award, the enclosed offer of settlement and stipulation agreement, and the enforcement thereof. By your default, you give, by remaining silent, irrevocable special power of attorney to claimants or their retained counsel to sign and execute for you on behalf of the respondents regarding the enforcement of your obligations under contract number, blah, 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 the award, and the offer of settlement and stipulation agreement. Now, we do all these things in the VSOF as well. I'm following basically what Stark did. Well, I expanded what I was doing based upon when I learned what Stark did. I was like, oh, that is so wicked to take power of attorney over them after you've already got an award on them. I'm like, that's some next level shit. So in the event that you instruct or authorize the claimants of their retained counsel to execute the signature on a respondent's signature in representative capacity on a self-executing irrevocable power of attorney document with respect to these proceedings and any and all matters related thereto. So he just took them. Therefore, know by all men by these presents that I, Eric Holder, Jr., by virtue of my office as the United States Attorney General, referred to herein as principal, my place of business being located at La 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 in the city of La La La, designate Bradley Christopher Stark of da-da-da, state of Kentucky, legal residence da-da-da, state of California, to serve as my agent and attorney, in fact, referred to herein as agent, to act in my name ex officio and for my benefit and to exercise the powers set forth below. Effective date, construction, scope of authority, revocation, confirmation of agent's acts, indemnification of active agent while carrying out authority, and then signature of agent. For identification purposes, a sample signature of my agent follows. This is Bradley Christopher Stark. And what did he do? Signature of principal, Bradley Christopher Stark for who? Eric Holder, U.S. Attorney General. Thank you. Have a nice day. Done, signed, sealed, filed. That's it. So then he could sign Eric Holder's name on whatever he wanted to, and that's exactly what he did, and that's why Congress had to pay those guys probably upwards of $1 trillion. Well, okay, not $1 trillion, but you saw the amounts, several billions of dollars at least. So again, as I said, just wanted to
just kill him.
Well,
what happened to him?
Do we know what happened to Stark? They were doing the same thing to Stark that they were doing to Drew. I don't know if they because they had him in custody. They had him in custody when Stark did this whole entire thing from behind bars because he had a bunch of people helping him and he was a fairly intelligent guy to begin with. Because the SEC was going after him for securities fraud of some stupid shit, which he wasn't guilty of anyway. I can't remember what the whole charge was, whatever. But he was learning the law anyway and had a lot of friends on the outside. So he got all this stuff done basically while he was in federal holding, I think in California. And I don't know if Stark's out yet or not. I think he is, but I'm not sure. But anyway, the bill was passed anyway. And it says in the bill that, there we go, right there, this part. Yep, Section 4, Affirmative Relief, A. All parties and beneficiaries that are natural persons and in their immediate family that are confined in any jail, prison, penal institution, correctional institution, or any other form form of official or unofficial detention under the authority of any state, territory, possession, or federal agency of the United States shall be unconditionally released from any such detention and set at liberty immediately and without further delay. Yeah, it's right there. Of which, by the way, I have that same clause in the KW. They cannot arrest you. Because, and they cannot arrest any of your family members either. Because think about it: if you don't protect the rest of your family and all the rest of the members of your house, what do you think they're gonna do? Yeah, exactly. So anyway, so he put it in there. So whatever they're doing, if they still have him in jail, it's unlawful anyway because of this. Because Congress passed it as a law that they have to let him out. So again, does anybody have any questions? You guys, and there's a lot of information that I dropped in the arbitration folder. So you guys got a lot of reading to do if you want to keep getting into this. So
maybe can you, unless somebody else has a question, say why this is, knowing about this information is important to sovereign Americans?
Oh, what are the practical? Okay, so okay.
What are some practical applications?
What are the practical applications? It's get your VSOF status doc set done, get it recorded, and then serve them so that any time that they ever come against you, they're automatically underneath the bus for, you can take them directly to binding arbitration if you want to, or you can do it in a court of record. You can sue them at law in a court of record for trespass in the case, and any other constitutional illegalities that you wish to do so. And because they're bound to the contract, they automatically agree that they have to be bound, and they agree that you can also open a court of record against them at common law and sue them for the administration of your estate, because this is what the entire system is based on, everyone. It's based upon the administration of our estates. That's where they get the credit from. That's where they push us all through the IMF, through the special drawing rights of the United States, through the IMF, and which is something that I showed you guys that I was with the group many years ago that we literally removed.
Share your videos about the treatise on American administration, because when you realize that they wrote a treatise about how to administer estates or abandon infant estates, you're like, oh, okay, maybe they are doing that.
Yeah, well, the treatise is about, these classes are more than just...
Greetings, citations, my fellow sovereigns.
Whoa, sorry, didn't mean to start it. Okay, so these are all the ones I've done so far, but this is the class on law of American administration. Again, I'm just going over a treatise, but it's a very interesting treatise because this is how they're administering everything. So you guys can watch that over probably a week's time.
You already dropped it. I was looking for it. Yeah, that's one of your more like specific classes, but it's good to see like the just even the what's it called? The practice of going through a treatise and reading it and looking up words. Like you basically have, you do that for us, which is great.
And yeah, Paul, this is everything that I do at the VSOF. There is no one right now anywhere in America that has a stronger set of documents that protects you than I do. No one. I've looked at David Straight's garbage. I've looked at Bobby Lawrence's garbage. None of them can get you on the NCIC do not detain list. None of them have any track record of doing that. Not only do I have track record of doing that, I just gave all of you guys a lien that shows that Drew has the entire state of Colorado under the bus. So I don't need to prove anything to anyone.
And what's crazy too is now I'm seeing on the Bobby Lawrence channel, they're starting to talk about what Zen has been teaching about for years and years and years. And I don't know, they don't give him any credit. So I just don't, I don't know how honest they are. And it's just getting kind of worse and worse.
Everybody eventually finds us. It's all a matter of time. Everybody that got sick and tired of Anavan dipshit's lies, a lot of them eventually found the VSOF. People got sick and tired of, or get stuck up, or ended up in watching people go to federal prison for doing dumb things like trying to set off their loans that they went and bought a new house with, or they bought a new car with, or whatever, and try and do debt forgiveness garbage. I saw Heather Ducey and a bunch of her dingbats sitting in federal jail for that. You just go to the core of the system. You reverse engineer and destroy what they're doing. They're doing everything that they're doing to us is by contract to consent. So what's the most logical thing to do? Wipe out all of the consent and turn around and give them the contract. That's all I did. I don't know why anybody else can't figure this out. But
yeah, amazing, and it makes so much sense.
But no one else is doing this. In fact, Bobby Lawrence can't even get the understanding of the jurisdictions of law correct, let alone even get close to what I'm doing. Yeah, there's Rick. Anything can ever be. There's anything you ever record onto public law, on the public record. Any documentation that you ever put onto the public record can always be amended. So when I ever have somebody that came from David Straight or Bobby Lawrence or Anna Von Dingbat or whatever, it doesn't matter. Anybody that comes, what you do when you file the VSOF status documents is you simply state, you can write at the top of it, and I just tell people you can just write it in by hand. That because the VSOF status docs come to everybody in a locked PDF. All you can do is print them. I don't allow anybody to change them. I don't allow anybody to take any information out of them, even though, I saw that David Straight was literally using an old version of the KW, though. I caught him. This was about a year and a half ago. I caught him using it. And then I told the person that informed me that David Straight was using an older version of the KW. I was like, tell David Straight that if I ever find out that he's still doing it, tell him that I'll take his head off. And I wasn't kidding. And then shortly after that, I don't think he was using it anymore. The KW is the document that I stated before, Rick. That's just, we refer to it as the KW. We refer to it as the kill warrant because it's
what does it stand for?
I showed you guys before, but I'll show it to you again in the start of it. The document means here, hold on, as this thing loads up. This is the name of it.
Yeah, kill warrant is the affectionate name because its real name is longer.
That's what it's actually called. That's its whole title. And as I said, David Straight had an older version of this, and he used it. And somebody said to me, "Hey, Zen, I think he's using your doc set." And I was like, it's impossible for him to use the whole doc set because he wouldn't have been able to get it. He's like, well, he's using a part of it. I'm like, show it to me. And they showed it to me, and it was part of the KW. It was part of the kill warrant, this document. So David Straight knows nothing. He creates nothing. He understands nothing. And Bobby Lawrence is just one idiot right behind him. That's all they are. They might get a few things right from time to time, but it doesn't mean that they can see it all. And you get one or two things wrong in this game, and you are done. But yeah, you can...
I mean, when I confronted Tia directly on our Telegram channel, I said, why are you still teaching people land, air, water as if there's 3 jurisdictions of law when that's just simply not true? And she says, oh yeah, we're evolving from our simplistic ways, and we're still learning too. I'm like, so that's how they're gonna play it. You know, just to say, oh, we're still learning too. Well, people pay to come to your seminar. People believe you. You got 4,000 followers. You're not gonna, it's not very honest. And especially because now apparently there's like an exclusive club that you can only buy into if you're ready or something like that. And they'll show you the real way to live in the private. That's what they call it. Being living in the private and not public sector.
Yeah, that's something, and they didn't invent that term either. That was a term that was, I think, created by either maybe Patrick Devine started using that term. I can't remember who started using that term, but that term's been around for very much longer than they've been using it. And you'll never find me saying that term at all. This has nothing to do with public and private. This has to do with consent. It has to do with contracts. It has to do with presumptions. That's what it has to do with. And by the way, Rick, I was going to answer your question. So what you do with the documents is that you put on the top of the document. This document amends in its entirety, public record number, and then whatever the public record numbers for David Straight's documents or Bobby Lawrence's, or I don't care. The Martian that came down yesterday and gave them to you. That's what you do. That's what you write them onto and yeah. So the status docs explain. Yeah, what I have a handbill, a very specific handbill for every single document that I have. So I'll give you guys that, which is the entire mega file.
I had some issue here. Okay.
Yeah, I'm just slowly talking. So I was going to add this to give this to Rick. So I'm going to show what's going on as far as the mega. So that, Rick, is the mega file that contains every single handbill that I have ever created and explains every single document as to how it's used, why I created it, what's in it, except that it does not give you the document itself, but explains everything. I let everybody learn every single thing that they possibly can before they do the VSOF status doc set. And I will not do it for anybody that just comes on and says, oh, help me. I want to do I want to do your process. No. If you don't understand what you're doing, I got no time for you. Everybody here excluded, obviously.
The handbills explain each document and what it does, and then also what you may or may not have to do to make sure it's in action, it's in effect. Like the one of the first one is the seal notice, and how to create your own house seal and why it's important. So it'll give you like some explanation of why it's important, what it should include, and then how to basically get it done and get like what's called an embosser. That's one of the first things. There's also a handbill or a to-do about the double authenticated birth certificate, but I think a lot of us have already done that, or at least know about it. And it's not any different than what we've learned, although I think it does clarify the different and authentication. And I was told, like, oh, there's no big difference. There's a big difference.
Yeah, it's a huge difference between authentication. And by the way, so you open that folder. I'm looking at it right now on Mega. So you open up that folder, and then you go to Start Here, it's the top folder. It says Start Here, handbills for each of the VSOF status doc sets. And then the first one, again, where it says Start Here, BC authentication. This is what you need to start doing right in the beginning because it's the thing that takes the longest to do. And then I explain what you get back after authentication from both the states and feds. I explain how to make your house seal. I explain the general handbills of how to sign and seal the status docs. And then also you can go and get your BC bond, your birth certificate audited so you can see how much the fidelity bond is on it. And then it starts in with all of the specific handbills. So Declaration of House Seal, the printable checklist for the status docs. This is what I need back from you in order to do them. So the handbill for the appointment of judicial coroner, handbill for proof of life and proof of age inquest, handbill for birth certificate claim, handbill for endorsement on the back of the BC, handbill for executor appointment, handbill for accession of power attorney, handbill for the fee schedule, the appendix for the child, the list of children. If you have children, you attach that to the KW. Handbill for the VSOF kill warrant. This is the handbill for the KW. Handbill for declaration of nationality. This is where you correct your status, and this is the thing that you make sure that you process serve to the both state and feds. And this is the thing that'll get you on the NCIC do not detain list if you do it correctly. Handbill for marshal appointment and special master appointment for your courts of record if you ever have to open one. So I just give these to everybody in case they need them. And then the history of the Office of Judicial Coroner. You can read that. It's kind of fun. And then treatise on the judicial coroners, administrator, the difference between administrator and executor, affidavit of service redacted. So if you don't have anybody that knows or you don't have a process server, you can just give this to anybody who's over the age of 18, tell them to go serve all your documents on that guy over there, and they do it, and then they fill one of these out, and it's done. And the list of trustees to serve. And then I said, contact me on Gilded about this because this is a pretty exhaustive list and it doesn't have to be everything on here, but I tried to make the list as big as I could. And then notice and demand on county recorder to file documents on the public record. So if they give you crap about not being able to file them on the public record, slide this across the table. And if that still doesn't work, then go find another county. But there's all of the handbills, okay? I explain every single thing that I do at the VSOF. It took me 1.5 years to write all these handbills out perfectly and get them formatted so that everybody could have a uniform understanding as to what the hell they were doing. Because my process is far too involved to just let people go at it willy-nilly.
Zen, is there any need to have our mother involved in our birth certificate as far as like...
No.
As handing it what?
No. Your estate is created. You're presumed to be dead. The presumption of infancy kicks in, and then, presumption of death and infancy kicks in. Your estate gets probated. It's then administered through the rest of the inferior courts by the special administrators. of which you can see when you go and listen to the classes on the Treatise of American Administration. It's all stated in there. And then no one comes forward to claim the abandoned estate. And you're the only one as sole lawful heir that can do so anyway. It doesn't really matter if the parents were the donors. That's irrelevant. And you claim all of the rest of your estate through the process explained in the handbills. So if you want to learn anything else about what I do, it's all there.
Yeah, I've been looking at your web page or your site yesterday. I've been scrolling through the announcements and looking at your mega folder and stuff.
Yeah, the VSOF master classes on the YouTube are probably the best things to go watch. And the status correction classes are there. So these are all the classes that I do for. That's the playlist for how you're. That's the playlist that I have for status correction classes. It starts with a really good history as to what happened to our states, and then it gets into the status terms, what you are and what you're not, and then the overview of the VSOF status classes, or the VSOF status correction process, and then it goes to very clearly through the status docs class, which I did, I think a year or 2 years ago, and I just got done re-editing it, and so now it's perfect. And then there's an arbitration, the arbitration on judges, proof that it works, which is more or less kind of the class I just gave you guys tonight, is the last one in that playlist. So.
Okay. Oh, thank you very much.
You're welcome. And so with that, I think I will stop the recording right here because I think we're pretty much done. Unless anybody else has any other questions. I can still stick around, but I just want to make sure that there aren't any more questions that we want to put on to the recording.
I think that was illuminating.
Why, thank you.
I'm good.
Okay, so with that, I will stop the recording. I will hang out with you guys as long as you want to afterwards. But so this has been the Vocational Science Freedom impromptu arbitration class at the Sovereign Americans United Gilded server. And I hope wherever you are, have a wonderful rest of your day, night, morning, or weekend. And until next time, stay safe and stay sovereign.